important one, which I will then take and with the committee's permission, also maybe link that somewhat to the struggles the information regulator has experienced to become fully operational. So I will then stick to that one. And yeah, sorry, 33, 34 has been taken. Let me just...
You can take any of those. If you want 33, you can choose, Werner.
No, it's fine.
I'm flexible.
Yeah, I'll maybe saddle the Honorable Breitenbach with a combination, Chair, if that's fine, of questions 11.
Question 11 is by Honorable Ngola.
Oh, sorry, my apologies. You know what, maybe we can just list all those that have been taken, and then I'll just inform her that she should choose one that has not been taken.
We have 8, 9, 10, 11, 15, 31, 32, 33, 34.
I think 28 has also been taken, Chair.
28 years by Honorable Chair.
Yeah. Okay, so that's fine. I'll then take 10, and I think the other one that goes to the struggles of the commission was number 13, yeah. So I'll take 10 and 13, and then I'll ask the Honorable Breitenbach to come in as with something that has not been chosen.
Okay. Honorable Nieuwoudt Drachen.
Thank you, Chairperson. I will take question 26.
26.
And 27. 26 and 27 if it's not taken, right? It's not taken, right?
26 and 27, yeah, they're not taken. Those are the questions, okay.
Yes, thanks.
Thank you very much. Honorable Whip of the ANC, what do we do with Honorable Khomozo? If she comes at once we start at 9:30, she will not be allowed to ask questions.
Agreed, Chair. We did raise with her, so let's just stick with that because we need to manage the consistency and the flow of the interview.
Yes, Honorable. Thank you very much. Are there any other issues that members would want to raise? I think we are done. So committee secretariat, the committee secretaries and the research unit, please ensure that by the time we sleep today, what is this thing? The report is ready so that we can quickly vote on the report tomorrow, and then it goes to the programming committee. Members, are there any issues that we want to raise? Honorable Nieuwoudt Drachen.
Sorry, Chair. I had my hand up earlier before we did the questions. I'm really struggling with my devices. I just wanted to ask, do we ask all our questions once, or is it question, answer while you check the time for 5 minutes?
Yeah, it's question, answer. Yeah, but we stick to the 5 minutes.
Okay. Thank you.
Yes. So the 5 minutes is yours to manage. But if the 5 minutes is up, it's up. Honorable Ramo Lebel, good morning.
Chair,
Hello, morning. Honorable Ramo Lebel.
I'm here, Chair.
Yes, we started at 2:15. We are choosing questions. I think that the questions were sent to you at 8:15. We have agreed that each member has 5 minutes to ask questions and get answers. Other members have chosen their questions. So can we give you 5 minutes to go through your questions so that you can be able to choose your questions? We will guide you as to which questions have already been taken so that you don't take those. Firstly, do you have the questions with you?
I'm trying to go through my emails now, Chair, but I've not received anything that says questions. The only thing I've received, it's the interview schedule I've seen. Okay, I found them on my personal email. I see them, but
You see them?
Yes.
So I will just guide you as to which questions have been taken by other members, so you will be able to choose from those that have not yet been taken. It's advisable to choose not more than 3 questions, because you must also allow space for the candidates to respond to your questions. Once the 5 minutes is over, you forfeit the right to get a reply and to ask further questions. Is that understandable, Honorable Rambulebe?
Yes, Chair.
Yes. Question 8, 9, 10, 11, 13, 15, 26, 27, 28, 30, and then 31, 32, 33, 34 have been taken.
Okay.
Did you get those numbers?
I got 8, 9, 10, 11, 13, 27, 28, 30, 31, 32, 34.
33. 33 is also taken.
Okay, 33.
So we will give you 5 minutes to go through the questions, and then you can advise us which of the 2 or 3 questions you would want to ask. Is that in order?
It's 2 questions, Chair. That one is given.
Maximum of 3.
Okay.
But it's advisable to get 2 if you have to stick to the 5 minutes. But you can still ask 3 if you are able to ensure that your candidate asks your questions straight to the point.
Noted, Chair. I'm going through them, then I'll bring them back to you.
Okay, sure. Thanks. Members, you can drink tea and coffee. We will come back at 2:15 so that Honorable Ramo Lebeng can advise us on the questions. Then we would wait for 2:30 to officially start. That
Chair.
will also, Honorable Jale.
Just for interest, I want to check with through you, Chair, our chief, our whip of the ANC, are we covered in terms of the house? Just for interest. Was he able to communicate? Thank you, Chair.
Honorable Janji.
No,
But I think before you say,
answer that because the committee is doing interviews, so every member of the committee is covered under that insurance.
yes. Yes,
Okay, thank you. Sure.
that's good. So I think let's come back at 1:15. That will also give time for Honorable Horn to consult with Honorable Peitenbach. Thank you very much. Honorable Ramolebole, you can now advise us.
It's Ramolobeng, Chair.
Ramolubeng.
Yes.
Ramolubeng. Thank you very much. My apologies.
Noted, Chair. The first one I took, it's number 1.
Number 1. Let me check if we are not. No, you start from number 5. Number 1 is by the chair. Part 1 is by the chair. We start
Okay.
from 5.
Okay, I took number 5 as well, so we can take that.
Number 5, yes.
So it means I need to identify a last one, because I had number 1 with. And number 29.
Check number 29.
Let me quickly go for the last one because of I had number 1.
I say.
Number 29.
And number 15, Chair.
Number 15. Let me check number 15. Number 15 is taken
Okay.
by Honorable Ngola.
You can also indicate here that 2 is appropriate. It doesn't have to be 3.
Yes.
Oh,
Yeah, 2,
Okay.
2 is fine. Yeah.
noted.
So you must ensure that you are able to extract maximum responses from the candidate within 5 minutes, because some candidates, you ask one question, he or she speaks for 5 minutes. So if that happens, then you will only ask one question.
Oh,
So we are giving you 5 minutes to manage your questions and responses for those questions.
noted, Chair.
Thank you very much.
Chairperson, my apologies.
Honorable Hall.
Yeah, I've since agreed with the Honorable Breitenbach that she will take 10 and 13, which I first said I will take, and then I will take 23 and 24, if that is in order.
Let me check 13. What is happening with 13? 13, was it yours also? Ne?
Yeah, I initially said I will take 10 and 13, and then I said to her, she can take those and I'll identify 2 others. So I've identified 23 and 24 in the meantime.
Just hold so that I'm even GP. And then it's 23 and 24 now, the new ones.
Yes, thank you, Chair.
Okay. Yeah. So thank you very much, Honorable Horn.
Chair,
Honorable Lamolube.
Since I've joined, my apologies for joining late. There was, I think it's Comrade Valma yesterday raised the clarity regarding the National Assembly sitting today at 3 o'clock. Have that been addressed? Because I remember the chair made an indication that he would speak to the chief whip regarding that, since I'm in Cape Town.
No, we are excused for today.
Noted.
The assembly knows that we are doing interviews for the whole day because those names must go to the House to be approved by the House. If we don't do these interviews, come the 30th of November, there will be no information regulator. And people's information, personal information will be at risk. So it's a very, very important task that we are doing.
Noted, Chair.
Thank you very much. So can we take another break until 28 minutes past 9? I know Honorable Horn likes to drink his coffee. So it's another round for you, Honorable Horn, to take another round of coffee.
Ek hoop 'n skoon koffie, nie 'n brandewyn nie.
Sorry, Chair. It's Sia, Chair.
Yes, Honorable Tenjani.
Yeah, thanks for the promotion, Chair.
Yes, you saw in yesterday night.
Thanks, Chair. I'm sorry, Chair. I want since your members are taking a break, can we allow the first candidate because they had the waiting room so that we can sort out in any terms of audio and so forth, so that we just start at that particular time.
Yes. Okay.
Okay, Chair. We will allow them in. Thanks, Chair.
Honorable Jale, is it a historic hand or your hand is up?
Historic hand, Chair. I'll take it down.
Thank you.
Thank you.
Good day, Ms. Bani Passard. This is here the committee secretary. We wanted to test your audio. We will be starting at 9:30 with you, but we wanted to just test your video and audio. If it's possible, can you put on your video and audio? If you can hear me as well.
Good morning. I can hear you very well. Thank you.
to Ms. Bani Prasad. How are you today?
Morning, Honorable Chair. We're well, thank you. How are you?
Thank you very much. Thank you very much, Honorable Breitenbach. Ms. Bani Prasad, can you deal with your audio? We can't hear you.
Good morning, Chair. Can you hear me now?
Yes, I can hear you now.
My apologies.
No, thank you very much. Are you fine today?
I'm fine, thank you. And yourself?
Thank you very much. Please be crisp when you answer questions. I only have 5 minutes with you to ask my questions. They'll be very brief questions.
Okay.
Tell us about who you are, your values, your experience, and why you believe you are suitable for appointment as a member of the Information Regulator.
Okay. My name is Archel Bani Prasad. I am a businesswoman. I also serve on the Transport Appeals Tribunal. I'm serving 3 terms there. I serve as a deputy chairperson of the Municipal Bid Tribunal in KZN also. I am from a transport economics background. I'm currently doing a PhD in transport, but my exposure through the tribunals have given me a good feel of something like the objects of the regulator. That's why I applied for this position. In all my undertakings, I conduct myself in a very professional manner at all times. I endeavor to always act in good faith, and that's one of my principles. Integrity is key for me, ethical practices, and I have a very forward-thinking approach to any task that I have at hand. I am responsible, and I have a chronic appetite for knowledge. So normally somebody would ask me, you know, you're in business, why do you want to venture out into boards and into this kind of scenario? I have a chronic appetite for knowledge. I want to spread my wings. I always want to learn new things. And I believe that I'll be a very valuable part of the regulator. I'll be able to contribute in a very positive way. I have very good analytical skills, and with my involvement in the tribunals, I've been exposed to lots of legal aspects. It gave me a perspective of legal protocols and you know, how to adjudicate appeals and lots of other things. I have developed an interest in case
Thank you
law.
very much.
Thank you
very much. Are you available to serve full-time or part-time as a member of the Information Regulator?
I'm not sure what it means to be a full-time member. Is it every day of the week or
Yes.
Every day of the week?
Yes.
Okay. If something like that has to be put forward to me, the deciding factor would be I'm based in Durban. Where would these meetings be held? Would I have to relocate?
How are you going to balance your responsibilities with your other responsibilities that you have? The responsibility of being a member of the Information Regulator and your other responsibilities.
It depends on the package being offered. Then I can make that determination. If I had to know what type of remuneration it's going to be, then obviously I'll have to weigh that against my my position at the other tribunals, and also balance whether I will be in a position to resign from business also.
Okay. Do you want to tell us anything that you have not disclosed in your questionnaire? Or firstly, do you want to confirm everything that you have disclosed to be true to the best of your knowledge? And is there anything else that you want to disclose?
No, I've declared everything, and there's nothing else that I need to declare.
there's nothing that you want the committee that should know, which if found out can put you and the regulator in a very compromising position?
No, there is nothing. Everything has been declared on the document.
Thank you very much, Ms. Banipasat. My name is Ulelani Gratitude Magwanisha. I am the chair of this panel and chairperson of the Portfolio Committee of Justice and Correctional Services. Members, is there a member who wants to ask a question or questions? Can you raise your hand so that I can see you? Honorable Janchi.
Thank you, Chair. Thank you very much. My 5-minute start. I just want to make sure that I pronounce you properly. Can you just do that for me? How do you pronounce your surname?
Bani Prasad.
Barney Persad.
That's right.
Okay, thank you. Now, can you please just share with this panel how the information regulator can have a proper balance between its responsibilities to protect personal data or privacy and the recourse that could be demanded by those who claiming a right to access to information?
Okay, the information regulator, to the best of my knowledge, is a custodian of the POPI Act and PIA now since July this year. And it has a duty to ensure the protection of personal information. And in order to achieve that, it needs to minimize, mitigate, and manage the invasion of privacy. So in order to achieve that, committees are set up where complaints are handled, enforcement is ensured, risk is analyzed constantly, education is disseminated on how the objects of the Act can be achieved. And in this way, the information regulator, sitting as a panel of members, have a duty to abide by the code of conduct and be ethical and confidential in all their undertakings, to uphold the values and achieve the vision and mission of as provided in the Act.
Let's pause there. I want you to give me a takeaway in one sentence. How do you balance the two extremes?
How do I balance?
Yes, I'm looking for that balance. That's the challenge here.
Maybe I didn't understand the question.
I'm looking for how you balance the responsibility of the information regulator in terms of it protecting personal or privacy, as well as those who demand that they have a recourse to access to information, regardless of whether it's personal or what. So I'm just looking for how you balance that. Give me a takeaway on that.
In one sentence, I believe the information regulator has the duty to protect citizens from the invasion of privacy in terms of its mandate as stipulated in the Act.
Okay, let's pause there. My last point. There's an argument that the process for accessing information as set out in PIA is very cumbersome and tedious. If you are an information regulator commissioner tomorrow, would you share with this panel the steps you would initiate to enhance community access to all of these PIA procedures? Got that?
Okay. The PIA Act has been in existence for a long time, but I'm assuming your question is around the implementation of the Act so that we could achieve the objectives. If I had to be a commissioner,
My focus is how you would initiate a process that would help and enhance community access to the prior procedures, because communities always are not having the kind of access that they should have.
yes, there must be information disseminated to the public so they are aware, create an awareness about their rights in terms of the Act as provided for in the Act, and the steps that one needs to take in terms of accessing information. There are different procedures for accessing state information and private information. For example, when it's private information, there's a need to prove that you need that information for the exercising of a particular right. So the steps that need to be followed need to be disseminated to the public by holding workshops and campaigns, information, sessions where people can become aware of that.
Let's pause there. Thank you. That's the end of our 5 minutes. Thank you, Chair.
Thank you very much, Honorable Janji. If you can introduce yourself to the candidate. I think I will ask every member to introduce himself or herself to each candidate when we ask them questions. Honorable Ngola.
Well, thanks, Chair. My name is Ngola. I'm the member of this panel for the interviews of the Information Regulator, and I'm the member of the Portfolio Committee on Justice and Correctional Services. Apologies, I'm struggling as well to pronounce your surname. So let's just shoot straight to questions.
Thank you.
What do you understand to be the role of the Information Regulator, and what specific matters does the Act require it to have regard to when performing its duties and powers?
Okay, the duty of the Information Regulator is to educate the public on the prescripts of the Act, to handle complaints that are received by it in terms of the infringements against persons' rights in terms of the Act. It considers policies and also international policies and whether they are in line with the prescripts of our Act and new developments in that regard. The Information Regulator has the duty to establish committees for each of these different sectors, like enforcement committees, dispute resolution, and compliance committees, to ensure that the objectives of the Act are reached.
Okay, why do you think POPIA requires the Information Regulator to be both impartial and independent? The question is why?
Why it must be impartial and independent? Because it is the custodian of PIA and the POPI Act to ensure that the rights of citizens are protected. So it's very important for it to be impartial and to conduct its business in a professional manner and make decisions without fear, favor, prejudice, to ensure that the objectives of the Act are actually, it gives expression to the Information Regulator has a duty to give expression and force to whatever is provided in the Act.
Okay. Last question. Do you believe that the Information Regulator should be included in the government discussions on the digital economy and the fourth industrial revolution? If the answer is in the affirmative, why do you believe so?
Considering the Information Regulator and its duties in terms of Section 39 as provided in the POPI Act, it deals with information protection. It gives effect to Section 14, that the right to privacy of information. And with the way in which technology is progressing now in terms of digitization, it is important for them to be involved in that process, because there's always new information systems coming into play in this country and all over the world. But it's very important to keep abreast with those systems and whether they are in line with our policies in terms of our legislation, which gives those rights of privacy effect and meaning.
Okay, thank you, Chair.
Thank you very much, Honorable Ngola. Honorable Dennis Breitenbach.
Thank you, Honorable Chairperson. I'm struggling with my device. I'm on my telephone, so please forgive me. Good morning, Ms. Bani Prasad. I'm Dennis Breitenbach, and I'm a member of this committee.
Good morning.
My first question to you, Madam, is now that POPIA is fully operational, you'll be joining the regulator at a time when it is in the process of shifting its focus to implementation. So if you are appointed, how would you contribute towards the regulator's success in implementation?
Thank you, ma'am. I think education is very important. There are a lot of new things that have emerged. This act is in existence for a long time, but because it was not put into practice, there's a lack of awareness. Information campaigns, awareness campaigns, all that will play a great role in letting the public be aware of what is their duties, what is their rights in terms of the act. And I think education is our main factor here to make people aware and allow them to understand the steps they need to take if their rights have been infringed upon, and also if they are business people or in any in any sector, they must know what are their rights, what are their duties in terms of compliance with the act at all times. Thank you.
Thank you very much. My second question is, what do you believe are the key challenges or risks that the information regulator faces as it goes about establishing itself? And what are your suggested mitigation strategies?
Okay.
But you can be brief. I don't expect you to give me a long detailed answer. Thank you.
All right. The biggest stumbling block is how to implement it. And I think the manner in which one would deal with this is to understand where the problems lie in implementation. So if we say education is one of it, we focus on education. If we say there's something else, we focus on that. But I think the stumbling block would come now at the beginning, at this stage. As we proceed to go forward, there will be more information that will emerge because complaints will come in, for instance, from more entities. And as we deal with those, we will establish where the weakest points are and deal with them accordingly.
Thank you very much.
Thank you.
Thank you very much, Honorable Breitenbach. Honorable Werner Horn.
Thank you, Chairperson. Good morning, Ms. Bani Prasad. I'm Werner Horn, and I'm also a member of the committee.
Thank you.
Welcome. My first question relates to an overlap in terms of legislation. You rightfully pointed out that the POPIA Act established the information regulator, but it is of course also so that in terms of data privacy, RICA comes into play. So I want to hear your views on how this committee and Parliament should approach the findings of invalidity of certain sections of RICA by the Constitutional Court in the Amabungani case earlier this year, where the court basically found that the manner in which interception and surveillance was regulated by RICA was unconstitutional and gave Parliament 3 years in which to rectify this. And in your advice to Parliament and this committee, what role, if any, do you think the information regulators should henceforth play in strengthening the regulatory and the oversight framework in terms of surveillance?
Well, I'm sorry, but I do not. I'm not familiar with that particular case. I don't know whether I should answer this question and how to approach it. I'm very sorry about that. I apologize.
So in principle, what would your views be then around the rights to privacy which South Africans enjoy versus the right of the state to do surveillance for security purposes?
I think that surveillance is crucial to give effect to rights in terms of the Constitution. And in order to balance that, our acts provide for mechanisms in which, or ways in which every particular instance of invasion of privacy will be dealt with. So I don't know in which context to answer that.
Okay, thank you. I'll move on to my next question then. This is about data breaches, let's say large-scale data breaches, and you would be aware that since the information regulator was set up, but POPI not being properly implemented yet, we've seen a number of big data breaches where the personal information of South Africans was shared or leaked. Experian, Standard Bank, and even of late the Department of Justice, where there was this hack with the possible exposure of the personal information. And in each of these instances, the information regulator issued a statement to say that it was not happy with these breaches and that it would engage these institutions around security of their IT systems. But I want to hear from you, is that sufficient, that reactionary role of the information regulator? Or is there something, both in terms of the act or then in terms of strengthening the act, which should be done in order to be more proactive and preventative? And what role should the information regulator play in this?
Okay, in dealing with something of this nature, it's important that the regulator be proactive. And look, this has national consequences if information is compromised. So it's too late to deal with the problem once it happens. It's more important to create mechanisms for parties to be aware of what their duties are and what they need to comply with in terms of the protection of data. So I think a proactive approach will be one that the regulator should take and facilitate engagements with the public and entities to ensure that they have their house in order and that there's no room for information to be compromised and rights to be infringed upon. That will eliminate eventual worst case scenario where we have the act there, but we don't have it being applied in the right manner. And we have too much of breaches. So I think a proactive approach is one which we should take at all times.
Thank you. Thank you, Chairperson.
Thank you. Thank you very much. Honorable Nivot Dragens.
Good morning, ma'am. My name is Wilma Nieuhout-Drugen. I'm a member of this committee. I use South African Sign Language, so the voice that you hear is that of the interpreter, Delphin. Okay, so my first question to you is in relation to the COVID pandemic. And privacy and data protection and compliance concerns have arisen. And it has served as a catalyst for increased data sharing. And so I ask is, what are some of the data protection concerns that you have identified in respect of the COVID-19 pandemic?
Good morning, ma'am. Thank you for that. COVID-19 has changed the way in which people conduct business and conduct themselves. It has made way for more use of digital technologies and systems, and that has, accelerated the need for the implementation of the prescripts of the Act, so that data is not compromised. I'm not sure if I got the second part of the question. You asked how should we deal with it?
I asked that, have you identified any concerns? What are some of the data protection concerns you have identified in respect of the COVID-19 pandemic? That was the second part.
Okay. The concerns would be that most of business is taking place online, and that opens a room for data to be compromised. So we need to look at ways in which to manage that through the Act and regulations.
Great, thank you for that. And then my second question is that South Africa has just held the local government elections, and elections by their nature require that all the different role players, so election management bodies, election monitors, all of them need to process personal data. And furthermore, digital campaigning is here to stay. It is important that this personal data is processed lawfully. So, could you please elaborate on this statement?
Okay, I saw in the media that the information regulator issued a media statement indicating that political parties need to be aware of this need for information to be collected, processed, and disseminated in an appropriate manner. And this again was a proactive approach. And I think it's very important that those parties adhered to that.
Thank you very much. Thank you, Chair.
Thank you very much, Honorable Nivot Truchens. Honorable Maseko Jele.
Good morning, colleagues, and good morning, Ms. Anipasach. I'm trying. My name is Nomathemba Maseko Jele. Can you see me, Chi? It looks like my camera, I'm not sure where I am. I can't even see myself.
You can see you proceed, Honorable Jele.
Can you? It's very uncomfortable for you to see me when I don't see myself. I have 3 questions for you, Ms. Bani Pesach. The first one would be maintaining balance between protecting citizens' personal data and ensuring their internet freedom can be very challenging. In your view, what role does the regulator have in maintaining this balance? That's my first question.
Okay. The regulator's role is mostly directive. It must direct parties on how they need to ensure that they comply with the provisions of the Act. And I mentioned earlier on that education campaigns and workshops are very crucial in ensuring that parties are aware of their obligations. And it starts there because most of the instances of compromise can take place if a person is not aware, or institutions are not aware of what the obligations are.
Okay, you're done. So, but in addition to that also, can you please provide us with the challenges as per your understanding of accessing information in South Africa?
Okay. Accessing information, the Act provides detailed provisions on how to access information, but the problem with that is there were no sanctions included in the Act previously. So also, if a person applies for information through PAIA, there was no obligation on an entity to respond. So if 30 days passed and that information was not forthcoming, there was no need for that person who received the request to respond to that application. So that created room for entities, especially state entities, to say, you know what, I don't have to respond, and if I don't respond within 30 days, it will be taken that the information, I'm not held accountable for that. So accountability is the main issue here, and I think the objects of the Act was to try and enforce service delivery and accountability, transparency. But because of no sanctions, it could have not achieved that. But now, since this is taken over, the information regulator has taken over control of that since July this year, that might change the scenario and give effect to some sort of regulation when an entity does not comply in terms of PAIA.
Thank you. I think you have just moved to my other question in terms of improving compliance with legislation. In your view, how can, because I'm saying this, the South African Human Rights Commission is having a concern. They are having concerns when it comes to the right of accessing information. They're saying the right of accessing information is not being fully or consistently realized. So as you have just mentioned, the issue of compliance, in your view, how can the information regulator ensure that there is improvement in relation to compliance with PAIA legislation?
I think, yes, I believe that enforcement is a secondary stage, but education comes first again. Circulars can be sent disseminating information to in the public domain, where people are aware of their duties in terms of PAIA. So that will ensure that they realize that the protection of access to information is such an important element of ensuring that the objects of the Act are carried out. So if they know the extent of what a breach can lead to, then they will know that they need to comply. So I think education, campaigns, information in the public domain would help a lot, will go a long way in ensuring this. Thank you.
Thank you very much. Thank you, Chair.
Thank you very much, Honorable Ramolube.
Thank you, Chair. Good morning to colleagues. Madam Ashi, I don't want to pronounce your surname because I would do injustice to it. I would have two set of questions to you, if you're okay with it.
Yes, thank you.
As a member of the Information Regulator, you will require leadership skills, but also be prepared to work with other members, accountable to the chairperson of the regulator. How would you describe your leadership style? And how would people who have worked with you previously describe you, both as a leader and as a team player, in your own view or analysis, especially with regards to those you have came across or worked with? Thanks.
Okay, thank you very much. I'm very diplomatic in all my engagements with people in whichever sphere. So I maintain confidentiality, and I think that will be one of the main things that falls within the code of conduct of the regulator. Also, ethics. I place great value on ethics. I conduct myself with integrity, and that's my value system. It's always been that way. So if I have to be a member of the regulator, I would conduct myself in good faith. Also, considering that I'm going to be working with people, I'll have a duty to ensure that I consider their views. And if in the event that I'm on the panel of the regulator and I have a dissenting view about something, I will have to consider the other views also, even if I still maintain my dissenting view. And if the regulator decides on a certain decision as a majority, I must ensure that a decision needs to be taken jointly. And even if I have a different view, if I had to put that decision into practice, I must support it in every which way. I must always act in the best interest of the regulator and avoid, conflict of interest, and I must respect decisions when working with other members.
Okay, Madam Ashi, and how would people who have worked with you previously describe you as both a leader and a team player? Because you have given me your leadership style or how you work. And in terms of a team player role, how would they describe you?
My team players always describe me as a very professional person who considers everyone's perspective, not just mine. So in that way, I'm regarded as very responsible and diligent, and I have a mutual respect for everybody who I interact with.
Thanks for that. In terms of the Protection of Personal Information Act, the POPIA also extends to certain key responsibilities in respect of the Promotion of Access to Information Act, which is prior to the Information Regulator. In your view, why is the right of access to information so important?
Every citizen has rights in terms of the Constitution, and Section 32 of the Constitution provides that everyone has the right to be informed. To give effect to that, PIA came into being. And access to information is important to give effect to that right in the Constitution. And information might be needed by a person to protect another right. So it's important that all those rights of people are protected. So that is why it's important that there is a mechanism in place through this instrument, through the Act, that allows for that process to unfold in the best interest of every citizen.
Thank you, Madam Ashi.
Thank you.
Thanks, Chair.
Thank you very much, Honorable Ramo Lubeo. Thank you very much, honorable members. That comes to the end of our interviews. If I can ask you a few questions, do you think the interviews were fair?
Yes, I think it was fair.
Do you think the questions were fair?
Yes, the questions were fair, only I might have not answered some of them correctly because I have not been part of the regulator. But if I am considered and get deeper into the workings of the regulator, I can assure you that the decision to accept me will not be one of regret. Um, uh, I think I have one or two more comments to make if you finish with your questions, if you can please allow me.
Proceed.
I believe that youth empowerment policies must be considered. And I know I don't fall within the bracket of youth. I just fall slightly out of that bracket. But in order to give younger people an opportunity on a structure of this nature, to allow them to expand their portfolios, it would be heartwarming to know that it has been considered. I'm not sure of age groups of other members who have been selected as shortlisted, but it will be heartwarming to know that that aspect of youth has been considered. And I make this submission with the utmost respect for this panel and with no expectation, but it's just a comment. Also, my second comment was in terms of section.
Ms. Bani Prasad, I think it would be important to limit your comments to the questions that I have asked about the fairness of the interviews, which you have answered. I think there will be other avenues to raise those issues that you are raising. We still have many other members or candidates to interview. I must just say to you that after we have made our decision, we'll make a recommendation to the House. The House still has to vote, but you will be aware because the information will be communicated by the 30th of this month because the term of office of the regulator comes to an end this month. So the House will take a decision very soon. Then it will go to the President. Then after that, the South African public will know who has been appointed.
My apologies, Chair.
Thank you very much. Thank you very much. We will now invite the second candidate to come in. Thank you very much, Mr. Bani Prasad. Enjoy the rest of your day.
Thank you.
Thank you very much. Can we invite the second candidate?
Yes, sure, we're on it. The candidate is still logging in, Chair.
Can we come back at 16 minutes past 10? We give you 3 minutes to ensure that the candidate is ready for interview.
Noted, Chair.
Gwanisha. I am the chair of this panel and a member of the Portfolio Committee of Justice and Correctional Services. What do you think, in terms of your experience, your values, you are the right person to be appointed to be a member of the Information Regulator?
Thank you, Chair. In terms of my experience and my qualifications, I am a legal compliance officer. I am an admitted attorney of the South African High Court. Majority of my career has been dealing with data protection, POPI in particular, and I have numerous qualifications in terms of compliance management. More notably so is the ISO 37301 of 2021, which is very fairly new. It came out this year, and it incorporates things and aspects such as cloud computing, AI technology, and data protection within the systems of data protection. As far as my skill set is concerned, I have advised on POPI. I have implemented POPI measures within companies. I've done it on levels of startups to multinationals to fast-moving consumer goods, as well as government departments. I'm a fast learner. I'm also intrigued in the development of POPI and what it means for South Africa as a whole within the space of the fourth industrial revolution, and the key aspect that POPI plays within that movement. So from that perspective, and in terms of what potentially I can bring to the table, I think I'll make a valuable member and good contribution to South Africa in terms of the protection of personal information.
Thank you. Are you available to serve full-time or part-time?
I am available to serve full-time and part-time. I just need to have clarity on what the requirements are.
Part-time, full-time, it means that you will be full-time in the office. You will not be doing any other work except the work of the Information Regulator. Part-time, it means that you can do other things and assist the Commission on a part-time capacity. Which one are you available for?
I am available for both. But I would prefer a part-time post.
Then if you are available for part-time, how are you going to balance your work currently and with the work of the Information Regulator?
I do balance my work because, one, I am an admitted attorney. I'm practicing and I have practiced in multiple mandates at the same time. So it is a matter of petitioning priorities and ensuring that the most top priority and time-sensitive and high-impact work is adhered to first. So I will be able to balance my time in that respect.
Can you confirm all what you have disclosed in the questionnaire to be true to the best of your knowledge?
Yes, sir, I can.
Is there anything that you would like to bring it to our attention? If found out, will bring the reputation of the Information Regulator and your own reputation into question?
No, sir, I do not think so, no. I think for full clarity's sake, I do have a YouTube channel in which I talk about legal updates and legislative developments. And I think from that perspective, that is full disclosure, and I do not think that there will be of any disrepute.
Thank you very much. Members, questions? Can you raise your hand so that I can note you? Honorable Janji.
Thank you very much, Chair. Morning, Mr. Pillay. You're speaking to Kubutile Janji.
Good morning, sir.
Member of the committee. With the 5 minutes I have, I'm going to shoot straight. Managing the time, you are in charge of the content, because it's the content that will distinguish you here.
Yes.
Just 2 questions I have for you. The first one, I'm going to ask you to share with this panel how the Information Regulator can have a balance between 2 critical things. On the one hand, it's a responsibility to protect personal data and privacy. and on the other hand, how it would promote recourse for those who want access to information, who are going to be saying, I don't care about personal information, I want this. How do we create that balance?
Alleged incidents of rights violations, whilst maintaining the balance between business and law. And through that, what I suggest is an online complaints workflow system. What we have, so from the education of the rights, we have an online workflow situation which allows for the data subject to write to the regulator to make an application online to say, I think my rights have been violated. This is why I think my rights have been violated, and this is the company why I think who is violating my rights. The information regulator would have a list of companies or information regulators, deputy information officers, which will correspond to that company. If they don't correspond to the company, that's our first line that there's no compliance. So we can then send a letter of note or an information notice to this company asking, listen, we received a complaint, please provide us with information. And then we can start with the internal proceedings with that. So our key turning point with that strategy is to ensure that the data subject knows their rights and is very clear on how to enforce their rights.
Let's
pause
there. Thank you very much. My second question is, and I want you to also assist here, the process of accessing information as set out in PAIA is sometimes regarded as very cumbersome and tedious. And I want you to indicate the kind of steps you would initiate to enhance community access to the PAIA procedures. You got the question?
So you would like to talk about how to make it easier for the community at large to access personal information. So when we talk about a question like that, we always have to talk about the infrastructural issues. It becomes complicated, especially the further out you go into our geographical locations, into the townships, into the rural areas, into the far-reaching spaces of South Africa. And that is the issue which we have to deal with. How do we ensure that the people who want to access information can access information? Unfortunately, you can't say that we're going to develop South Africa in every aspect, in every geographical area of South Africa. So what we do have legal clinics going around. We do have the ICASA setting up internet infrastructure going around. We do have companies like the DBSB, who are working with intuitive technological developments to improve South African access. So when it comes to the geographical location, we approach a partner to develop model in which we use the legal space or the legal clinics to help members of the community who may not understand the legal jargon, who may not understand what the procedure is, to fill out those application forms, to facilitate and send those emails on their behalf, in addition to having a legal person, a legal mind, guiding them along the way. That you want to find out why your water is polluted and why your water is not tasting right. This is the information you need to ask for.
Let's pause there. Find that interesting, but my time just ended. Thank you very much.
Thank you very much.
Thank you very much, Honorable Janche, for minding the time. Thank you very much. Honorable Hon.
Thank you, Chair. Good morning, Mr. Pillay. My name is Werner Horn, and I'm also a member of this committee.
Good morning, Mr. Horn.
Thank you. My first question relates to communication surveillance. And whilst the information regulator currently, all of their duties and functions are spelled out in the POPI Act, it is so that in the Amabungane case, our constitutional court has confirmed invalidity or unconstitutionality of certain portions of RICA, specifically in respect of how the state should go about getting the permission to do communication surveillance. So given that also is in the realm of rights to privacy and limitations to that, and that Parliament now has 3 years since which started February this year to amend the Act. How do you think when we go about amending the RICA, should we consider strengthening the legislative framework? And do you think the information regulator should play a role in when we amend the legislation or in the amended legislation?
Thank you, Mr. Horn. That is an incredibly detailed and complicated question, but I think the larger issue that we have to deal with there is the surveillance of communications. We are doing that on a national level, and we are aware of that because of our local cases and our national cases, that we are saying that, yes, certain aspects of communication surveillance is important, but we also have to consider what international communication surveillance is doing to us. To that aspect, we've got to look at how we're transferring and allowing our information to be communicated. POPI does deal with transfer of information outside of the Republic of South Africa as well as internally of South Africa. But what we do is that we have a conditional data transfer of information, meaning that only if the country has similar laws to POPI can they process information. If we say there's no conditions, what's going to happen is there's going to be unfettered access to information, and that's what we are seeing here at this point in time. When we talk about RICA and when we talk about other pieces of legislation in the financial space, the labor space, and other information spaces, we have to have a say in terms of the information regulator. We have to say what information to what degree is allowed to be communicated for what purpose. Obviously for national security, but what is the definition of national security? We can't say for criminal surveillance communication that we are now monitoring all access because we want to watch for the breach of our law. We have to find a balance in terms of RICA, which we have to have a say in as an information regulator. The degree in which and what we have to say in the amended piece of legislation would be to categorize what types of communication, what types of information will be subject to national oversight and communication watch. The difficult thing, the balance that we have to achieve when it comes to communication awareness and watching is that we don't become a police state. We don't appreciate the right of freedom. We need to know where the security of South Africa comes into play, as well as where the balance of the freedom of expression is and the freedom of speech. So when it comes to RICA, it has to be in terms of POPIA. It has to adhere to the conditions of POPIA as well as the international transfer of information in terms of POPIA.
Thank you. Sorry, I have another question, and my 5 minutes is running out. So I want to talk to you about big data breaches. So since the information regulator was set up, but not fully functional yet, we've seen Experian, we've seen Standard Bank, we've of late seen the Department of Justice cyber attack. And in all instances, the information regulator said, well, we're dismayed and we will engage with these institutions to strengthen systems. With your specific background and knowledge of the Act, what can the information regulator do to be more proactive, or are we bound to a situation where it will always only be able to react to these type of data breaches? Thanks.
Thank you. When it comes to that type of question, I was anticipating this type of question, and unfortunately, we cannot say that we have to be proactive in the sense of preventing cyber crimes or cyber attacks in South Africa and our businesses. Purely because the cyber criminals are more resourced, they're more skilled, they have more access to information, and they are able to adapt to what we're doing. However, that doesn't mean the information regulators' hands are tied. What we can do and what has been done in multiple fields within South Africa is we need to have a mandatory. Yes.
Mr. Pillay, I'm afraid your time is up. Honorable Neville Dragens.
Good morning. I'm Wilma Neo-Druchen. I'm using South African Sign Language. The voice that you're hearing is my sign language interpreter, Trudy. My first question relates to the following. With the global spread of COVID-19, generated numerous privacy and compliance concerns. That the pandemic, there are concerns that the pandemic has acted as a catalyst for increased data sharing. What are some of the data protection concerns you have identified in respect of the COVID-19 pandemic?
Thank you, and thank you for the question. In terms of what COVID-19 has done is really just unearthed the issues that already existed. The fact that we come home and we connect to our work laptops using our home Wi-Fi, which is not not subject to the same protections as your work Wi-Fi, which has 3 levels of security and 3 levels of firewalls and data monitors and things. That's one. 2, unfortunately, children are unpredictable. When they get a laptop, they see a laptop active, they see a flash drive, they put it in, they watch the movies. You don't know what websites they're going to, if they even are, but it may just be for a moment, it may be for an hour, but still is going to be placing our access null points as risk. The way in which we communicate to our other team members, we use WhatsApp. We don't use a business WhatsApp account. We use online share. We use an online IM system. Things like Teams come with business Teams for business or Skype for business comes with secure chat lines, which we could be using and needs to be implemented. Using multiple computers at once. I mean, if we're transferring information on Gmail because we have Gmail on our phone, it's more easier for us to access, or we're going to an event, we need to send information. Who are we meeting with today? Please send me the information, send me the details. I've got a Mr. So-and-so from here, and this is what we're talking about. Done. And those are not malicious things. Those are our everyday exercises in which we are doing. We are exercising those rights just as what we are doing. So COVID-19, as much as that is new in itself, it has just unearthed what we are already doing and the violations and security breaches that we are currently exposing ourselves to. So the question from there is, what do we do? Things like adding a 2-factor VPN access to our laptop. So when we log on using our home network or a coffee shop network, we get access via our phone and we confirm the access via our phone. The next thing, what we do is that we don't allow USB flash drives and certain websites and certain video sharing stream sites access to our work computer. Furthermore, what we can do is,
thank you very much. Yes, thanks. My second question. We just had our local government elections, and by their nature, it requires all of the different role players like election management bodies, election monitors, observers, and political parties to process personal data. Now, also, digital campaigning is here to stay, obviously, and it is important that this personal data is processed lawfully. Now, can you please explain that?
So I just need clarification on the question. Are you asking me is in terms of political parties and cold calling? Sorry, yes.
Well, whatever role player, whether political parties or whatever, they have they have to process personal data, but legally, I want you to explain to me what the legal process is with regards to that and the impact.
Okay, so thank you. So my approach would be with that is to ensure that we have consent to keep your data subjects information on file. We need to ensure that our consent is up to date and we have written proof of it.
We seem to have lost our candidate. So can you phone him?
On it, Chair.
Hello, Chair, can you hear me?
Yes, you are now back.
Oh, my apologies. I'm not too sure what happened there. Oh.
We have 1 minute left, Mr. Pillay.
We need to ensure that we are getting the correct consent for continued direct marketing, and we need to ensure we keep a list to ensure that we have contacted our constituents and that we have received consent as in that regard. Thank you, Chair.
Thank you very much. Honorable Glenys Breitenbach.
Thank you, Honorable Chairperson. Good morning, Mr. Pillay.
Good morning.
My name is Glenys Breitenbach. I'm a member of the committee. My question is a short one, and you can be brief in your answer. Now that POPIA is fully operational, you would be joining Regulator at a time when it is in the process of shifting its focus to implementation. If you are appointed, how would you contribute to the success of implementation?
Thank you. Thank you. So I have experience in terms of implementing POPIA on startups, on multinationals, government departments, and also fast-moving consumer goods. My experience in terms of POPIA from an academic perspective has been from its initiation in 2013. I am an ISO 37301 compliance lead implementer, so I do know and do understand the best international standards for implementing compliance measures and within the systems of any business. By nature, I also hold a business systems analysis qualification, which allows me to analyze different business systems and ascertain the requirements of POPIA and amalgamate them into one cohesive unit. I also hold several Lean Six Sigma belt qualifications, which deals with process efficiency, and I can adapt those methodologies and the Kaizen methodologies into this implementation. I have been implementing compliance measures. I have been interpreting legislation. I have been analyzing businesses and establishing and designing control measures and reporting lines for monitoring.
Thank you very much, sir. And then my second question is, what, in your view, are some of the key challenges or risks that the information regulator faces as it goes about establishing itself? And how would you contribute to mitigating those? Or what would be your suggested mitigation strategies?
Well, the number one risk would be being unable to achieve its mandate, being unable to enforce the rights of the data subjects. So one of the ways that we can ensure that we meet our mandate, protecting South Africa, whilst making sure that the business of South Africa is in balance, is that we need to be an intermediary between the two. We need to allow for that dialogue between the data subject, to have them being able to complain or to lodge their grievance with us, and for us to meaningfully engage with the responsible parties registered and the information officers registered with us. It's not about a matter of just simply dishing out fines. It's a matter of ensuring that we can find a way that to ensure that non-compliance is not a thing. Obviously, fines is there as a deterrent, but what we need to do as an information regulator is ensure that we are a wealth of knowledge, we are willing to help, and we are willing to enforce. So that is our approach, that what we should take, more of a change management approach as well.
Thank you very much, sir.
Thank you.
Thank you very much, Honorable Breitenbach. Honorable Maseko Tshela.
Thank you, Chair. Good morning, Mr. Pillay.
Good morning. Good morning.
Good morning. Chair,
we can see you, Honorable Maseko Tshela. Proceed.
Yes, Chair, I am proceeding. Mr. Pillay, in your view, what role does the regulator have in maintaining a balance between protecting citizens' personal data and ensuring their internet freedom? But also, let me just add the second one, which can go with that one. What would be, in your understanding, the challenges in South Africa in accessing information? You can answer them just once.
Okay, thank you. Thank you very much for the question. What's the information regulator's balance or role in ensuring that we are achieving access to information as well as protecting business? Is this my correct statement of your question?
The first one is protecting citizens' personal data and ensuring their internet freedom. Then you can come later on the challenges in accessing information in South Africa.
Thank you. Thank you very much. So the information regulator's role in protecting personal information of South Africa is critical. Not only is it critical in the measures and the punitive measures it takes to ensure against non-compliance, it's the measures it takes to protect the South African citizens from threats from abroad. Not only must the information regulator deal with the issues of non-funding non-compliance or inability or ignorance, it must take steps to ensure that our information stays localized. Our information stays in a state of data information and goes to data intelligence within South African borders. We can only protect our personal information, the right to free our freedoms in that respect, if we have enough control over that. That could be through establishing partialized data localization, which ensures that the servers that contain South African information are within South Africa. We therefore have our mechanisms and our jurisdiction over those servers to ensure that you are complying with POPIA. We can do our audits, we can check with you regularly. You do have an information officer, and we can reach out and negotiate, and we can interact with you on the turn, as opposed to just dealing with an international organization. We don't have jurisdiction. We don't have a point of contact. So the critical role that the information regulator is going to play in the protection of personal information of South Africa is to ensure our personal information remains in South Africa, allowing us to make it information intelligence. And how do we increase the access to information? I would presume we're talking about PAEA and in terms of POPIA. One of the key things is where our information sits when we use the Internet of Things, when we use our Fitbits, when we use our phones and things. We need to ensure that businesses are keeping an updated list on a centralized database that the information regulator is holding or has access to say that these are our data subjects and this is what information we hold of them. Not particularly the information itself, but the information type. PAEA can be written in to include exercises of data redundancy or information redundancy being written into file plans, document retention and document storage. Those are things that ensures that data redundancy, document redundancy are all available when requested. By having our information in different languages, it ensures that the vast majority of South Africans can access that information. Employing techniques such as text-to-speech or speech-to-text allows impaired to access information. These are all small but very effective mechanisms that we can employ to ensure the access to information whilst protecting South African personal information.
Thank you very much. The last one, it's about how can information regulator ensure that there is improvement in compliance with PAEA legislation?
PAEA legislation. Thank you.
We have less than 1 minute.
We need to make it an audit requirement, for example, being for the Auditor General when they're checking BE compliance, PFMA compliance, MMFA compliance. We need to make it an audit requirement that there needs to be a PAEA requirement. You do have an updated PAEA requirement. It has been updated by your board or stakeholders. That's for the public sector. For the private sector, make it an audit requirement, just as the Labour Department would check for employment equity, BE scorecards. It needs to be an audit check that for the information regulator that we are checking that there is a PAEA manual. That's one of the ways that we ensure that there is one present. Thank you, Chair.
Thank you very much. Honorable Mola.
Thank you very much, Chair. Yeah, my name is Olangola. I'm the member of the committee.
Good morning, sir.
Quickly, you only have 5 minutes to interact between myself and yourself. The first question would be, sorry for that. What do you understand to be the role of the information regulator, and what specific matters does the Act require it to have in regard when performing its powers and duties?
Thank you for the question. So what is my understanding of the information regulator and what they do in terms of South Africa? Quite simply put, the information regulator needs to balance the rights of the data subject with the right of the business or the rights of the responsible party to conduct business. The way in which it does that is through oversight, national oversight, policy creation and policy monitoring, as well as audit checks and monitoring. So policy advocacy entails that we look at what the threats and what the trends to do with data. And unfortunately, because it's data, it's an international exercise. We've got to look at what the world is being affected by, because more likely than not, we are going to be affected by it. And we need to do it in a way that entrenches or it covers the enshrined rights of the Constitution within South Africa, and whilst ensuring that it doesn't become onerous on businesses running or operating in South Africa, that it is the barrier to entry or the barrier to run business is so high that it is not worth it. So it is a balancing act at the core of the information regulator to ensure the enforcement of the data subject rights while protecting the right of the businesses and the responsible parties to exercise their right to business. And you asked me about the specific requirements in terms of the legislation of what the information regulator does and how it needs to do it. Am I correct in that?
What matters must it take into regard when performing its duties?
What matters, it needs to take into consideration our Constitution, number one. It needs to take into consideration global trends in terms of economic development in the digital space. So our digital economy is based just very much similar to the African economy, is that we have the raw materials, we send it out, it comes back as a finished product. We need to take into consideration this exercise to ensure that we are taking our raw data and we are transferring it into information intelligence within South Africa and developing value in it. We need to consider the trends such as the cybersecurity trend. We need to understand that yes, we will never be ahead of the cybersecurity threats, but we can exercise those rights. We can mitigate those rights by ensuring exercises like having cybersecurity insurance, having that or prescribing that as a prescribed insurance. So we do this in South Africa within many spaces. We have UIF, we have in the legal space, we have the Fidelity Fund and the information and the insurance in that respect. Okay. Yeah, sorry.
Okay, I think you have given a satisfactory answer. The next question is, why is the independence and the impartiality of the information regulator so much important in terms of the Act?
Is very important because if we are exercising for both parties and if we are biased to, let's say, business, no matter what the data subject is going to say, we are not going to find any non-compliance and find or correct any exercise that is not compliant. By the same side, if we are only for the data subject, we are going to make and advocate policies which are extremely stringent on business, which makes it very difficult for business to maneuver within this space. Essentially, we're going to drive business out. And that's not what we want. We want our impartiality and our confidence as an information regulator. We need to have that instilled trust that we will fight for what is right and the principles of processing personal information lawfully and in the best interest of South Africa. Okay.
Do you believe that the information regulator must be included in the government discussions on the digital economy and the fourth industrial revolution? If the answer is in the affirmative, why?
My answer is in the affirmative. Solely because the fourth industrial revolution is based on the technologies of AI. One of the key aspects of the pillars of AI is big data. And if we are not in the conversation about how we are collecting big data, how we are collecting it safely and lawfully, then we'll be setting ourselves up for a fall, because we'll be working on information and working on our fourth industrial revolution on information that's unlawful. That's not the only reason why we should be involved in the conversation, the next conversation we should be involved in with 4IR is algorithm and algorithmic bias. That is a concept where if we are using faulty information or we're using unlawful information, we feed it into an algorithm to make decisions automatically, what's going in is what's going to come out. So if we're putting in unlawful information into our algorithms, we are putting out unlawful outcomes.
Thank
So
you
if we
very
are-
much. Thank you very much. Honorable Ramolebo.
Thank you, Chair. Good morning, Mr. Pillay.
Good morning.
My name is Elthia Ramolobeng. I'm a member of the Portfolio Committee and also interview panel. I would
Nice to
like
meet you.
to give you two questions.
Yes.
As a member of the Information Regulator, you will require leadership skills, but also be prepared to work with other members. Accountable to the chairperson of the regulator, how would you describe your leadership style? And how would people who you have worked with previously describe you as both as a leader and as a team player in that regard?
Thank you. Okay, so starting with what my leadership style is, I am collaboratively independent. So I'm able to work with a group. I am able to work very comfortably on my own. I have been a practicing attorney for a good couple of years, and having different stakeholders, having different parties in the same matter is one of the norms. And I have worked very effectively with the group, with the reporting to a chairperson and to a shareholder. And I have worked independently as well. I'm currently working. I do have multiple reports to the CEO, to a chair, to different committees, and I do work well in that space. I am able to work effectively, independently, and also very effectively in a group. I would be described as a professional when it comes to how I lead. It's a matter of what has been done, not a matter of what I think. It's what I can see that's going to affect my decisions, and I make decisions on intelligence and not just basic information. I believe I've answered you.
Okay. The second question would be, COPIA also extends to certain key responsibilities in respect of the Promotion of Access to Information Act, which is prior to the Information Regulator. In your view, why is the right of access to information so important?
Thank you. The right to access to information is the first key to exercising your rights within the Bill of Rights. If you don't have information, how can you exercise your rights effectively? So ensuring that we have access to information that is complete and accurate is something that needs to be